It's a pleasure to have you, sir, with us in the Bar and Benches exclusive interview series. Um, so the first question, which I don't think is out of place here, do you enjoy the tag of being called one of the most successful criminal lawyers in Madhya Pradesh, or does it come with its own set of responsibilities?
First of all, I'm thankful to all of you. In fact, it is not the question of tag. The satisfaction comes from within itself. One who enjoys the work is satisfied. So any tag, it hardly matters to me. I keep on working day and night, that's all. So my entire satisfaction is with the accomplishment of the work and labor that I put in, my commitment, my honesty.
So there's a question which every lawyer mulls over in their initial days of practice: civil law, criminal law. How did you make the choice?
I don't think so. One has to make a choice. It depends on the circumstances and the office which you join. I started with Mr. Y. Dharmadhikari and Mr. Dutt. Mr. Dutt is a stalwart in criminal law, and Mr. Dharmadhikari was in constitutional law. So I had put in about 7 years with Mr. Dharmadhikari and about 5 years with Mr. Dutt. Finally, I started getting criminal work. I was labeled more as a criminal lawyer. But then every lawyer, I think, if he has a basic understanding, I always say ki, this profession is something you should be inquisitive about the things and the law. I'll put you an example. A child is there. The best learning process can be from the age of 4 to 8 to 10 years, 12 years. Why it is so? Keeps on asking questions. He asks his father, how is it this? Why it is? What it is? So these are the questions which a lawyer is always required to ask. If a lawyer is really intelligent, he can excel in any of the fields. The question is to gather the facts, apply the law, and anyone who is intelligent can apply any law. Except for the procedural part, I would say that you are required to learn the procedural part. If you are practicing in the civil side, then of course you should know how to draft a plan, how to put a WS, how the issues are required to frame. If you are working on the criminal side, then of course you should have an exposure and the experience with the trial courts. Unless you have an exposure with the trial courts, I don't think so any lawyer who is working on the criminal side can really excel. I don't say no one has excelled, but of course I think one who has really practiced in the criminal side before the trial courts understands the niceties of the trials, the Evidence Act, the criminal procedure. And these are the, as far as the criminal law is concerned, I say these three. Now of course there are divergent fields. POX is there, other terrorist activities are there, sedition is there, all those things are there. But there are 3 acts which basically I say one should be well aware. Number 1 is the Indian Penal Code, which speaks about the normal penal consequences. The second is the Criminal Procedure Code. Every young lawyer should really understand the Criminal Procedure Code. He should understand what the trials are, what are the summon cases, what are the warrant cases, what are the sessions cases, what are the summary cases. Every lawyer is required to understand the Evidence Act. I'll give you an example. See, just now I was discussing with them. Under the Indian Evidence Act prevailing in our country, the confession given to a police officer, that is not admissible. In England, it is. Those were the people who framed our laws. Just try to understand this part. Why is it that they thought this? It should be inadmissible as far as India is concerned, but as far as England is concerned, it is admissible. Probably they understood the policing system which was prevailing at that point of time. So I always say a lawyer is really required to understand the facts, the procedure. Unless you understand the procedure of a trial, because one may say, I am practicing in the appellate side. This is not required. But then the application is required to be made before the appellate court also. Say for example, you come across the evidence which says, the statement was signed. Immediately you are required to understand section 162. It says 162 speaks about the applicability of section 161. 162 starts with the phrase, it should not be signed. So if you don't understand that part, how do you apply it? So I always say for a young generation lawyer or a first generation lawyer or any lawyer, start with the criminal trials as far as criminal law is concerned. Understand the criminal law before the trial courts. Merely reading from the books is not sufficient. You are required to understand all those things which are taking place inside the court, how the lawyer is managing the craft, how the judge is speaking, how he is placing the questions. All these are the requirements which I always suggest to a young generation lawyer.
Sir, a very little less known fact about you, at least to the media, you have had a number of face-off with judges. In fact, direct face-off with the judges on administrative issues or maybe issues involving judiciary as well. Um, First of all, you have to highlight some of those instances to us because it needs to go out in the press. And secondly, does it hinder your judicial practice?
Second part I'll answer first. I don't think so. Your legal aggression or your outspokenness gives any hindrances to your legal practice. You should be prepared with your matter. I don't think so any judge can harm you. And more so, I would say that judges are not there like this who are going to take into account all those things and harm you. It has never been the case. But to come out openly is a requirement of the honest part of a lawyer. I always say कि we have good people more in number. जो गड़बड़ लोग हैं वो थोड़े से हैं. They are very less in number, but they overshadow us because the good people, they are not saying anything. Occasion arises when we are required to come up. We are required to fight for the institution, not only for the cause of the lawyers. It is the question of preventing the rule of law and fighting for the cause of justice. If a judge is going wrong at this stage of mine, at this stage of my career, if I do not point out, then I think I would be failing in my duties also. Some occasions have arisen. There was a point I just now told you also before this commenced. At one point of time, there was an order which was passed by the district judge vigilance saying this: all cases of acquittal would be examined by the vigilance. I was the president of the Bar Association at that point of time. I raised an objection to this. Immediately, the Chief Justice at that point of time was Justice A.K. Patnaik. He immediately recalled that order. So there are moments. I had certain issues as far as the appointments are concerned. The last example which I may put, I always say, we are not required, the collegium is not required to consult the bar, but then a transparency is required to be maintained so as to apprise at least the bar that which are the names which are being sent for. I really understand that process, that collegium system is there, all those processes. Bar is not there. But then I still feel for the purpose of transparency, the involvement of the bar should be there. There should always be maybe a hidden consultation. It should always be. There was an issue when Justice Rajan Menon, who was the Chief Justice of this, acting Chief Justice of Madhya Pradesh High Court, lastly he was the Chief Justice of Delhi High Court, his name was recommended by the collegium. This was in that particular year, December. Suddenly in January, there was a change in one of the members of the collegium, and his name was missing. Those recommendations, they were wiped out. I wrote a letter to the senior counsel. At that point of time, I was just a senior counsel, nothing beyond it. I was not the president, I was not the secretary, nothing. I wrote a letter. I thought that it is my duty to point it out. I wrote a letter to the senior counsel of Madhya Pradesh High Court saying this was not being correctly done. A meeting was convened. My letter was treated as a resolution in that, and that was forwarded. Ultimately, nothing happened. All of us know. But then issues are required to be raised. We can't be a silent spectator to whatever is happening. Let it happen. So we have to rise to the occasion.
But can any lawyer raise this issue, or you have to be of some stature before you raise these issues?
Any lawyer. It's not the question of stature. Every lawyer has a stature. A lawyer is a lawyer, I say. Senior, junior, it doesn't matter.
Is it easier said than done?
Pardon?
Is it easier said than done? A hierarchy indeed exists in the judiciary.
No, it is not easier. I would not say it is easier. But then one has to come up. You just can't say wait and watch. Rise to the occasion, fight for the cause. Fight doesn't mean you are required to scold a judge. Doesn't mean that. I always say, see, we are there for protecting the rule of law and of course the judiciary also. They don't have any plan. We have a platform. Say for example, I am talking to you. I can say anything within certain parameters. They don't have any platform. Where do they say? We go daily, we criticize judges. This is not a correct order, this is not a right order. Every day, every lawyer comes out and says. Where do they have a platform to defend themselves? Counter allegations are made. Every day we are seeing this. Firstly, I say that the lawyers are also required to act with a responsibility. They are not required to criticize judges for everything. They are also doing their job, working to the best of their ability. You are required to raise a cause which is really justified and legal. This is how I place every lawyer owes a duty to this institution. Rise to the occasion, don't be a silent spectator. Maybe you may not be heard.
So, what is your take on the sealed cover jurisprudence?
I don't agree with it. Openly, I am saying. Why a sealed cover jurisprudence? See, if we go by Magna Carta 1215, right to liberty and property that was recognized way back in 1215. Article 21 is the backbone. You say that opportunity is required to be given. When you say this, why this hanky-panky job of sealed cover? Put it openly. Let the other man also know what is against him or what is going to come up against him. So I don't believe in that.
So, being designated a senior in Madhya Pradesh High Court and also being a senior member of the bar, how do you feel the process is different as compared to being designated a senior from the Supreme Court?
See, initially when I was designated as a senior advocate, things were different. And earlier the High Court used to suo moto, the full court used to designate. For the first time in 2012 when I was designated, a process came into effect. There would be a voting. A 10 lakh income tax slab was created and there was an individual voting, a secret ballot.
This is the Indira Jaising case?
Before Indira Jaising. I was designated in 2012.
2012, okay.
So at that point, it was for the first time that this voting pattern started. It was for the first and the last time. 10 lakhs of income tax, all those things, they were there. After Indira Jaising's case, things have changed now. Interviews. I still say no, they are not required. It is an honor which is required to be cast upon a senior counsel. You recognize his worth, let the High Court designate him. And still, under the rules also, still that provision is still existing. It has not been taken away from it. It is either way. Invite an application, a secretariat has been created, all those things are there. And secondly, the High Court can also do it. So why is it that the High Court is not doing that? Instead of inviting all these criticism,
there should be no application with
I don't think so. Senior counsel is something prerogative of the looking to the recognition, the worth of the person. Because senior advocate is like an ambassador of this High Court. When he goes out of Madhya Pradesh High Court, say for example, when I go to state of Uttarakhand or Uttar Pradesh, I take the name of this High Court along with me. One may not say, who's this man? One may really say, there was some senior advocate who came today. So it should be something like that. And this can only be done by honoring that man, bestowing that upon him by the full court.
So the Supreme Court recently granted bail to Indrani Mukherjee. I'm sure you're aware of that case. And Justice Nageshwar Rao's bench only ordered that. But there was a very important observation in that entire order that since the entire case is based on circumstantial evidence, there can be no chance of tampering the evidence. I wanted to get your opinion on this. How far is this correct? Not on judgment of the court, but the reasoning behind this.
See, sir, the law of circumstantial evidence is concerned. For the first time, somewhere in 1882, it was for the first time developed in New Zealand. 1952, the first judgment from our Supreme Court, that is Hanman Singh's judgment. And then the landmark judgment came, that of Sharad Birji Chandra Sarda. There can always be an area of tampering with any evidence. It may be circumstantial, it may be direct. Unless it's a documentary form, electronic form, one may not be able to tamper. But circumstances can be of number of, it is not confined to one thing only. There may be circumstances which are leading to the commission of an offence. So, for example, a recovery of a weapon, last seen evidence, all these are circumstances only. Say, for example, last seen, it would be based on oral evidence only. What can be the circumstances? One who is saying that I had last seen him along with so and so, would it not be oral evidence? So, there is always an area of tampering with any evidence. One cannot say, circumstantial evidence cannot be tampered with. A part of the oral evidence would be required over there also. Of course, a documentary evidence may not be tampered.
But can a bail be granted basing on this?
See, bail, I think when we look to Balchand's judgment, Honorable Justice Krishna Iyer, as he then was, those observations probably we have forgotten now. Bail is the rule, jail is an exception. That we have forgotten. Bail is, during under trial, I always say that the attitude of the court should be liberal. And probably something like a phobia is being created now. I'll give you an example. I filed an application for anticipatory bail in one of the cases over here. There are two cases. I'll just give you an example. There was an application for anticipatory bail which was filed. It was entirely a case which was based on the fact, I may be slightly long. It was based on a closure was filed by the police saying this, he is not involved. He is found in the CCTV footage at Jabalpur, so and so, 100 kilometers away from the place of the incident, and he could not have been there. A closure was filed. The magistrate directed for a further investigation under 173(8). Further investigated. Again, a charge sheet, a closure was filed saying this, no case is made out. Same set of facts were there. We filed an application on these ground. The High Court was kind enough to grant anticipatory bail for 302. There's slightly an exception circumstance. It went up for cancellation before the High Court, before the Supreme Court. The Supreme Court cancelled it, giving various reasons. I'm not into that. Now, I subsequently filed an application under 439. The same judge rejected it. A judge who granted under 438 rejected. Now, what was the reason? What can be the reason? I at least could not understand. The same judge granting anticipatory bail at one point of time, after cancellation of bail, because the parameters are different for cancellation and grant of bail, they are different.
Right.
Now, the same judge rejecting under 439, at least I don't find any justification. Probably it requires courage with the judges also. As long as you are acting under, I would say that no, you are afraid of something may happen, you may be transferred. All these areas should not come into play in the mind of the judge. He is required to be as independent as he is. Another example I'll give you. A 376 matter, 439 application, girl having an affair, promise of marriage, all those things, bail granted. Cancelled by the Supreme Court, taking into account that Bhaiyaji back theory. What is this Bhaiyaji back? You must have heard about that.
Of course. This is Seriousness of India.
Okay, I really don't understand. How does this Bhaiyaji back affects the grant of bail or the condition or violation of the condition of bail? Was this a condition of grant of bail? I can't even, or some sect of the society, they are saying, or they are the follower of that man, they are saying Bhaiyaji.
Were you in that case?
I was in a different matter. On the same consideration, this bail has been cancelled by the Supreme Court. So, what are these theories which are being generated?
But I think Justice Kohli's reasoning was that atmosphere created around that entire.
See, unless that atmosphere is to the extent that the prosecutrix is just living in a despair, or really threatened to that extent, or I would say psychologically she is being affected by all these atmospheres, one can understand. There is nothing on record to indicate this fact. If there is a psychological imbalance with the prosecutrix on account of this following, on account of this juluses, dharnas, etc., is she being affected? So there are certain areas which I think, see, judicial activism is one thing, and overstepping it is something different. There has to be a line of demarcation.
Sir, what is your take on the current condition of forensics and national lab testing facilities, especially with regard to areas like Jabalpur, Guna, Bhopal, etc.?
Not very good.
And how does it cause delays, or how can it improve?
Opening the labs, putting in more number of labs, more number of experts. One more thing with this, I would say that in fact, say for example, DNA reports are there. Even in a country today, we don't have expert lawyers who can really cross-examine an expert who is given a report of the DNA. And we have been occasioning all those things that reports have not been correctly given. Sampling has not been done correctly. I suggested some There was a workshop in Delhi probably about 15 years back. Justice Deepak Mishra was the acting Chief Justice over here. I made a suggestion that some right of investigation at the stage of investigation may be given to the accused also. Very difficult matlab. I don't know how this proposition can be accepted by anyone in our country. But then I feel, because what is there with him is solely dependent upon the report, the test, the investigation done by the prosecution or by the investigating authority. This is a time when some changes are required to be incorporated. It is for the legislation to think into all those things.
So, which are the top 3 laws according to you in our country which are misused the most by lawyers and litigants to derive unjust benefit? It's a very direct question. Just name the laws for us.
The Evidence Act. If you ask, misinterpreted or misused by the lawyers or by the litigant, it is the Evidence Act. See, procedure is not part of it. Procedure, as far as the trial part is concerned, that is there with the lawyer. As far as the investigation part is concerned, the lawyer doesn't have any role to misuse that. It is for the police. So, as far as the evidence part is concerned, because the witnesses are involved, the evidence is involved. So, that is the main act which can be misused by the lawyers or by the litigant. I don't think so by the lawyers. I have never found that a witness coming to my office, I am suggesting something to a witness. I have never entered into that practice. Those are all litigants who does all those things. They may be doing it. And I also say, it is not always necessary that the witness, if he is supporting the accused, he is always misused or he is wrong. Maybe that the police has misused. What is the 161 statement? It is an unsigned statement recorded by the police officer sitting in his office, records your statement. Why one can't say, this is a misuse of authority by the investigating authority itself? I think a good lawyer would not misuse it. One who is really practicing law, he would go by his ability with his understanding of law.
Any other law apart from the Indian Evidence Act?
As far as the misuse part is concerned, I think the law of sedition is being misused not by the lawyers but by the investigating authorities. मुझसे ज़्यादा आप लोग जानते होंगे इसके बारे में.
Of course.
So, a relook is required.
What is your take on UAPA?
UAPA, in fact, the litigation is not over here, therefore I may not be able to comment on that, because that litigation is not over here at all. The NSA is there, black marketing is there, detentions are there. There are certain areas which are not, say for example, company laws, they are not in Madhya Pradesh High Court, at least in Jalpur.
Government has started the process to amend the Indian Penal Code and the Criminal Procedure Code. A panel is already looking into it. Since you have practiced so extensively in these areas, which are the prime areas which is in need of urgent amendments or attention?
A very urgent need, in fact, is about the search and seizure which are being conducted by the police, which in fact, according to me, in the last 39 years, have not found to be correctly done. Hardly stray cases are there where they have really investigated the matter or have acted sincerely or honestly. All these searches, all these seizures are affected sitting in the office, getting signature of 2 punch witnesses. I say that whenever a search is conducted or a seizure is affected, it should be recorded. The longitude, latitude, everything is there. So that is required to be generated. Today I am coming across cases where the narcotic drug seizure is made in the police station. They show an interception at a particular point of time. See, the installation of cameras have been well taken care in Paramveer's case by the Supreme Court. But how many police stations are really equipped? When we make an application, they come down with a fact, no, it was not working. Why it is not working? Can you just flout the orders of the Supreme Court like this, saying this, no, it is not working? If it is not working, who is required to be taken to the task? Secondly, one more area where I would really suggest some amendment to it. That is in fact in respect to the explanation which is given. See, there is a proviso which has been added to section 161. Proviso to the third subsection 3 of section 161. A proviso has been added, which says audio and video recording should be done or can be done of a statement which is being recorded. Now, this is just contrary to section 162, I would say, because 162, it puts an embargo on a statement recorded in writing to be signed. Now, if this is, what was the intention behind it? Let us understand the intention behind the incorporation of these words under 162, that it is not required to be signed, so that the witness may not be bound over in the court with the previous statement. That was the reason. Now, if you audio and video record it, then the purpose of 162 is frustrated. So, something is required to be done as far as this proviso is concerned, because or you are required to incorporate something in 162.
There is no harmonious construction.
No, not at all. देखिए, एक सवाल आदमी पूछता है कि आपकी तस्वीर है, जब 161 के स्टेटमेंट को दिखाता है, कुछ और बोलता है, तो ही जस्ट आस्क अ क्वेश्चन प्लेइंग दैट ऑडियो एंड वीडियो कि दिस योर पिक्चर, ही सेज यस, दिस योर वॉइस, ही सेज यस, एंड ऑफ एवरीथिंग. So the purpose which was there for 162, that 161 statements are not required to be signed, that is frustrating. I gave this session when a seminar was organized by Gujarat Law University, National Law School probably, and this was done in collaboration with the Jagran Lake University, Bhopal. I spoke on this. Mr. Balraj Chauhan, he was one of the members of the Criminal Law Reforms Committee, was there. Justice Ved Prakash was there, myself was there, and I gave all this. There were a number of sessions which are given by me. I don't know what happens to these sessions, where they do go, I don't know.
They had actually opened up this Ministry of Home Affairs had opened up a small help desk in which you could send in suggestions for reformation of criminal law, etc. In the last date was last week or something. Also, a point just taking from where you left was the Supreme Court was hearing a habeas corpus petition very recently, wherein a person had gone missing during the COVID period.
Mm-hmm.
And the very same point occurred that, where was the CCTV footage? The state AAG had to submit that they were not working. And the bench opined that they are not surprised at all.
The bench should not only be surprised. Yeah. A stern action is required from the bench. See, any prosecution today, recently there was a judgment by Honorable Justice Sridharan where he found that the entire case of the prosecution was false. He settled the prosecution with a cost of 42 lakhs. Because the man lost about 14 to 20 years. He was going to be a doctor. He was. Are you
talking about Chandresh Marsok?
Recent judgment.
Yeah, I think that is.
Now, this is required to come up, so that they are also put on a check. They can't just put any case against anyone. It is becoming very difficult. The only hope, I always used to say, this is my personal belief, I say that the judiciary and the army, armed forces, not only the army, the entire armed forces and the judiciary, they are really the hope of the country. If they fail, probably we may fail. A litigant, when he goes to the court, see, revolutions take place because the masses come forward. This system is an individual oriented system. The masses came forward, say for example in the case of Shah Banu. When masses came, things changed. But because this is an individual oriented system, क्या हुआ, एक को सजा हो गई, क्या फर्क पड़ता किसी को कोई फर्क नहीं पड़ा. It is he, the individual and the family that is affected. So therefore things are not coming up to that extent. The day it affects, the system affects the masses, things are going to change. And they'll have to change. Every one of us will have to change. I am not talking about the judges only. I don't say, judges are working day and night. See, a judge required to dispose of 150 cases in a single day. It really requires a very hard work. And for that, I hold the lawyers also responsible. See, you had one case before a particular bench. A judge is equipped with 150 cases. You did not come prepared with a single case. He is prepared with 150 cases. So it is really difficult. A lawyer is required, therefore I say, whatever you do, make preparation like this. You are not required to fondle with the pages over there. It should be all over here.
Sir, there was a much talked about judgment from the Supreme Court regarding every sinner has a future. It was criticized in several quarters, etc. But my question is, what is your take on the reformative model of incarceration? Do you think that works? And also, is death penalty needed in statute books?
It may work to a certain extent, not always. because it will all depend upon the psychological balance of the man. I'll give you an example why I say psychological balance. You must have come across dowry death cases. Number of facts, you must have seen number of cases. I'll give you an example. A mother-in-law tells the daughter-in-law, "You're just a characterless girl." She's happy, smiling, laughing, going away. A mother-in-law might have said, "You did not prepare the food nicely today. You did not ask anyone to eat the food." She's so hurt, she commits suicide or she dies. Now, this is an area, I would say, a psychological balance. So every sinner has a future would depend on the psychological balance of the person. It cannot be universally said to be correct.
And do you think death penalty is needed in statute books?
I don't think so. I don't think so. As far as my view is concerned, death penalty is required to be wiped out. For the simple reason, say for example in 376 or POXO cases, till the last breath you are inside. No future, nothing is there. So why to put a man in the gallows? He dies his own death. Nothing is left with him. Family realizes seeing him कि नहीं, ये मेरे परिवार में किसी को नहीं करना है. आज आप उसको डेथ पेनल्टी, इफ यू गिव हिम अ डेथ पेनल्टी टुडे, ही पासेस अवे. हमारे इधर जो भी न्यूज़ रहती है 24 घंटे की रहती है, 24 घंटे, 1 महीना, 15 दिन, दैट्स ऑल. एवरीवन फॉरगेट्स. लेकिन दैट मैन हु इज बीइंग इनकार्सरेटेड फॉर हिज एंटायर लाइफ, the entire family and the people who are just around him, they will not forget that. Because he is alive and he is not with us. And the entire life is going to remain like this. It will remind you of what he has done, one should not do. Maybe a message to the society, to those people who were close to him.
So my last question to you is on police reforms. In May itself, there were 3 police encounters in Guna, Madhya Pradesh. And also Madhya Pradesh is known for its now and then occurrences of encounters, etc. Where, inevitably the blame lies on the police force, agencies, etc. Do you think there is any immediate scope of police reforms to be taken up? And also, if it can be implemented as soon as possible without going through the red tapeism, etc.
Immediately reforms are required. Immediately it should be taken up. Liability, responsibility of the police official, they should be fastened. And that cadre of police department, it really requires training and reforms. One should, I'll just give you an example. You go to a police station, you'll never feel happy. Even if you go to make a complaint, I've lost my mobile, you'll not be happy. An example I would give you, Mr. Rajesh Pilot used to be the Minister of Telecommunication one point of time. आपको बहुत पहले याद होगा जब हम कंप्लेंट को फ़ोन करा करते थे, might be I don't know at your age, but I have experienced that when you used to give a call for a complaint of a telephone, तो वहाँ से जवाब आया था, yes complaint क्या है. This used to be the mode and the way. When Rajesh Pilot came, he said the first reform that he made was this, आप बात तो वही कह रहे हैं, what's the problem? Why can't you say good morning sir? How can I help you? And it started. Things changed. So in fact, the first is the attitude of the police personnel which is required to change. I also say, no, because of them we are sleeping properly, cool head से हम लोग सोते हैं, बड़े आराम से हमारा रात गुजारते हैं, because of those people who are roaming around. But then attitude is required to change. The manner of investigation is required to change. They can't do everything sitting in their office and preparing papers.
Because of the entire subject of police reforms have been pending for several decades. So can it be taken up at the state level and implemented, or does it have to have the sanction of the?
But reforms are required to come now. High time. The country has changed. A lot of things have come up. Changes are for good. So they are also required to change.
So my last question to you is, when we talk of being first generation lawyer, how difficult was it to make it into the profession? And secondly, do you believe that nepotism has crept deep into this profession?
The first part, I think it is not required that generation should be there so that to become a good lawyer. The first part. As far as nepotism is concerned, I would not use the word nepotism in fact. I'll put it slightly differently. Nepotism is something just favoring someone for some reasons, all those things. I would say liking and dislikings. The better term would be there. I have an affinity towards someone for some reasons. Maybe I may have an affinity with my daughter. She's my daughter. She's doing well. I may have an affinity even tomorrow. Say, for example, I'm not going to be a judge now. If I had been a judge, I would have an affinity with my young junior, saying this, she was doing very well. So these are all questions like, I don't think so still that part of nepotism, up to some extent I would not say. Yes, affinity, liking, disliking, they have entered. It is there.
Right. And have you ever considered that one day you will be elevated to the bench?
I got occasions. Thrice I was asked.
Thrice.
And
which are the years?
I'll give you. Justice Rafat Alam was the Chief Justice, 2010-11 must have been. Before that, Justice A.K. Patnaik, he can always confirm ki I asked him, I called him, he said no. He always says whenever he's there on a public platform and I'm there, he always say he's one man who refused. So not for any other reason, not for any extraneous reason. The only thing is I thought that it is better for me to serve the institution from this side. I was always vocal, always outspoken, which probably my voice might have been curtailed sitting over there. So those are
your voice would have been curtailed on the bench.
Not you can't speak that way. I said that they do not have any platform where to speak, except for the judgments or the orders. I don't think so. Judge is required to come in a conference or give an interview to the press. I don't appreciate that. You could have whatever you could have said was through a pen in the judgments.
But these days judges are appearing in a number of conferences.
They should not.
5 in a week.
I don't think so. They should appear. They are required to be aloof from all those things.
Is this a message to the Chief Justice of India?
Yes, I say the judges, they should not go for the interviews. They should not appear in the media. They should not, one more message I am giving, they should not share the platform with political authorities. I am giving a very blunt statement.
And is it applicable to all the judges?
All, everyone. I don't say they are not human beings, but there are certain areas where they should exercise their constraint and restraints.
No, because it has become really common practice for the Law Minister of the country and the Chief Justice of India, or Law Minister of a state and the Chief Justice of the High Court to grace an occasion and speak at the platform.
I don't think so it is required. You require a consultation where they are on papers. Everything can be done through the papers. Why is it required? A platform is required, a big board is required, a mic is required. I don't think so. Therefore, I said I never opted to become a judge for these reasons. I would have been the last man to go for all those things.
Right. And so, which is a senior member of the bench or judge that you have always looked up? It could be someone who is retired. It could be someone who is there serving now.
We had very good judges. When I entered the bar, the Honorable Justice G.P. Singh was there. Interpretation of statutes, you must have heard. He is the author of that. He was the Chief Justice of Madhya Pradesh High Court. I never had the occasion of appearing much before Justice J.S. Verma, who became the CJI. Then Justice D.C. Verma was there. He passed away. He was the Chief Justice of Himachal. Went from here only. Then Justice Sharma was there. And in recent time, there are a few very good judges. Prakash Srivastava, Justice Prakash Srivastava, Chief Justice Calcutta High Court. Then Justice Alok Arade, probably Administrative Judge Karnataka High Court, a very good judge. And Justice Ravi Jha, presently the Chief Justice Punjab and Haryana. These are all able and good judges. And presently also some of them are there, very honest, very able, hardworking. Not even a whisper against them. So see, if a judge is, I really understand ki because two parties are involved, two lawyers are involved. There's always a criticism by either of the parties.
Right.
Every day we hear something he doesn't understand. He didn't understand the matter. It's very easy to say. And who is saying this? A 2 years lawyer. A lawyer who is put in 2 years, he is commenting on the competency of a judge. So they are coming across all those things. But then they don't have to retaliate on that. And they are not retaliating. They are working, keep on working, that's all. We have a very good judiciary, we have a very good institution. The only thing is it is required to be strengthened by people, by some people who may come forward for that. I don't know if I've said much or I don't, but whatever was within my heart, I always speak from there.
Thank you so much for being with us in this interview series.
Thank you so much. It was a pleasure meeting all of you.